I am attorney Allison Reddick, and with me again is VA accredited agent and Marine veteran Carrie Baker. This is where a lot of the veterans that I've interacted with and have is the Thailand and
Oh, wow.
Guam and things like that. So
Thailand's kind of my baby too.
Mhm.
So, all right. So the next section is titled Presumptions of Service Connection for Diseases Associated with Exposure to Certain Herbicide Agents for Veterans who served in certain locations. One sort of overarching thing, they're taking away Vietnam, served in Vietnam, in support of Vietnam, and now it's going to say certain locations. And so the statute's now going to define all those locations. So this section is adding Thailand, for all you Thailand veterans, to the list of presumptive exposure to herbicide agents will now be conceded anywhere in Thailand during the Vietnam era, and interestingly ending on June 30th, 1976, which confuses me a little because the Vietnam period ends May 7th, 1975. And the internal regulation was always consistent with the same time frame as Vietnam. So that's a little odd. It says in a section term, covered service means active military, naval, or air or space service performed in the Republic of Vietnam during the period January 9th, 62 to May 7th, 1975. But then the next section is performed in Thailand at any United States or Royal Thai base, that's important, during the period beginning on January 9th, 1962 and ending on June 30th, 1976, without regard to where on the base the veteran was located or what military job the veteran performed. So there's your Thailand presumption that goes.
No more having. Yeah.
I don't know why it goes. I'm sorry.
Go ahead. Go ahead.
No.
I was going to say no more statements of having to say I was this close to the base of the perimeter, and this is where I lived, and it was open air, and I saw this and that. No more of that. No more saying you had to do guard duty. No more of that. If you were on the base, you're covered.
And we should do a video sometime on Thailand. It's just, I'm thinking out loud here. I might get fired from videos. On all the ways VA has tried to walk back Thailand, all the different types of claims that you just pull your hair out of your head as to why they're denying.
Or remanded.
Right. Things
so
like,
remands.
On and near meaning two different things, on or near, not the same thing. VA coming out and expressly saying near means on. Well, we wouldn't have written on or near if they meant the same thing. So not using DoD's own research as to how far herbicide drift when ground spraying apparatuses were used. This is research they did years on to figure out exactly how far you need to be away from things you don't want to kill. All right, and they determined at least 500 yards. So if that's a spray drift, why wouldn't you use that as near? If DoD considers it near enough that that's where the drift's going to go. Little things like that. I'd love to do an episode because VA is not, Allison hit it right on the head. VA is not going to be able to come out and deny those silly things any longer because of this presumption. And
so you mentioned not using DoD records. So then my thought is, okay, are those DoD records considered service records? And then they were originally denied and you can reopen it because they didn't use those records originally. Is that a possibility? And that's for another video.
Yeah. So, all right. So moving on to this section, also, it not only adds Thailand, it adds Laos, about time for that, from December of 65 through September 30th of 69. So it doesn't cover the entire Vietnam period. But that's approximately when we sprayed herbicides in Laos, especially along the Ho Chi Minh Trail. That's been in contemporaneous military reports for years and years. I had a case not long ago where I swear VA acted as surprised as one could be that we use herbicides in Laos. And so no more of that. You now have to presume it. Same thing for Cambodia. at Mimot or Krek Kampong Kam province. I hope I'm pronouncing that right, Allison. If I'm not, if you can do better. But that's only from April 16th, 1969, ending on April 30th, 1969. Now, here's the big one that everybody's waiting on. Guam. You guys are really not going to want to hear that I didn't agree with this one. But hey, I say that, no, I will fight like hell for any Guam case and have won plenty of them. I just didn't really agree with the presumption of exposure for Guam. I've never saw that the evidence is really there, but it is now.
Yes.
It said that section says performed on Guam or American Samoa or in the territorial waters thereof. So not just on Guam, during the period beginning January 9th, 1962, which is the beginning of Vietnam, and wait for it, to July 31st, 1980, 5 years after Vietnam ended, or served on Johnston Atoll, or on a ship that called at Johnston Atoll during the period beginning January 1st, 1972, and ending on September 30th, 1977. Why is that important? Now, this one I agree with. Johnston Atoll is where all the herbicides were stored when they were banned from being used in Vietnam. They shipped them all up, took them to Johnston Island, and they stored them there. Now, interesting here, this period is from January 1st, 1972. I don't think they got there at January 1st, 1972. I think it was in 73 or 74. But you know, the law now says it's 72. And 77 is when they were burned at sea. So they were all loaded up in a ship, an incinerator ship, sailed out to sea and burned at sea. So that is why we have the ending date of September 30th, 1977. Now I'm a little surprised, and this goes to the uneducated, which there are many in the world of legislation and regulations and exposures. And I'll just say this, because this will be future litigation, I have no doubt. You know, they stopped using herbicides in Vietnam in 71, 70 and 71, depending on if they were coming out of a C-123 or being used as ground spraying apparatuses around perimeters, things like that. So different forms of delivery stopped at different times. But Congress extended the presumption of exposure all the way to 75. They did that because the same reason they did it for DMZ, the same reason they did it for C-123s. That is the environmental persistence of dioxin and Agent Orange. It didn't go away very quickly. It stayed around in the soil and the plants, so you could still be exposed to it. So that's not being applied to Johnston Atoll, you know, clearly, and probably some others. Laos, they stopped in 1969 from my recall of the records, but the presumption is not going beyond 1969. So on that note, I expect that we will end up litigating part of that at some point. But nonetheless, Guam goes from the beginning of Vietnam all the way to July 31st, 1980, to include its waters. Johnston Atoll, January 1st, 72 to September 30th, 77. I read that to include its waters as well. How are you going to tell which ship stopped at Johnston Atoll? I don't know yet. That's going to be another bit of research that somebody's going to have to do. All right, so that's it for, make sure that's it for, no, that's it for the herbicide presumptives, but let's talk about effective dates and applicability. Okay, this is important. It says the amendments made by this section shall take effect on the date of enactment of this act. In other words, as soon as the president signs it into law, shall apply as follows. On the date of enactment of this act for claimants for DIC, we're a little pattern on DIC here, and for veterans whom the Secretary of Veterans Affairs determines are terminally ill, homeless, under extreme financial hardship, more than 85 years old, or capable of demonstrating other sufficient cause. Beyond that, it's October 1st, 2022 for everyone else. All right. So those are the presumptions we just talked about. that list, terminally ill, homeless, extreme financial hardship, those are all the things that VA will expedite a case for, to include advancing the case on the docket at the Board of Veterans Appeals. So if you're in that category or you're DIC, then you get adjudicated when the act becomes final. Otherwise, they don't start till October 1st of 2022. Some of these offsets, and this is not the only one, they're going to be set out in the future, is because this bill is so big, it would be physically impossible for VA to implement all of it at once. Right. So this is going to come in phases.
So on that,
Allison, go ahead, Allison.
it says more than 85 years old. That's the age for expedite at the regional office. At the board, it's 75. So
correct.
So are they going to continue it to be 75 at the board? And if you're at the board with these issues, you're going to get a decision sooner?
Yeah, this statute doesn't change that. The board's regulations say 75 for all cases. And so they will continue, because unless they do a proposal to change their regulation, which I highly doubt that. So yeah, I think that at the board, all cases for vets 75 or older, or claimants for 75 or older, are going to continue. Yeah, they should have done it 75 and older here, but we've always wondered for eons, me included, even as a former employee, I don't know why the ROs do it at 85 and the board does it at 75. I just think that's a little ridiculous. So
I agree.
All right, now also sticking with herbicides. All right, we've got two new presumptive diseases. One is hypertension. Everybody's been waiting on that. The other one is MGUS. It's monoclonal gammopathy of undetermined significance. Don't even ask me what that is. I'm not 100% certain. It's been floating around for quite some time, along with hypertension, as the next potential, presumptive disease for herbicide agents. And now it's going to come to light. The effective date provisions for this are the same as that we just went over. All right, October 1st, 2022 for everyone that's not DIC or terminally ill, homeless, extreme financial hardship, or more than 85 years old, or some other cause. Now, I'm going to read.
So for the MGUS, that's just an abnormal protein in your blood that it creates a condition. I've never come across a veteran that's had it, but I'm sure there are some out there. And the hypertension, that's a lot of people, but are most of them going to be 0%? But hypertension, that can lead to a lot of other conditions for secondary, heart disease, diabetes, kidney, chronic kidney disease and such. So, that's why I look at it that way. But also the rating for hypertension is supposed to be based off of what your readings were prior to medication. So just put that out there too.
Now, I want to read one paragraph just as it stands here. Now this paragraph is in the hypertension section and the monoclonal gammopathy section. It says, notwithstanding any federal court decision or settlements in effect on the day before the date of the enactment of this act, the Secretary of Veterans Affairs shall award retroactive claims for a condition under section 1116A2L of Title 38 United States Code, as added by subsection B of this section, only to claimants for DIC under chapter 13 of such title described in subparagraph A1 of this paragraph. Now, for those of you not trained on Nemer, I read that as they have just legislated out Nemer for these two conditions for everyone except DIC claimants. Now, I might be misinterpreting that because, I'm not a federal judge. I don't get paid to interpret the law, but that's what that sounds like. I know from my own experiences, VA has wanted to legislate out Nemer on a lot of things that Nemer would otherwise apply to. It looks like they convinced, and the only way they could do it was to get Congress to do it. There's no way VA ever had the authority to do anything with Agent Orange and say Nemer doesn't really apply, but Congress can. And here where they say, notwithstanding any federal court decision or settlements. All right, the Nemer case was both of those, a federal court decision followed by a settlement. And I know that's what they're targeting there. So be that as it may, it doesn't look like, but now if you're the vet, let me kind of rephrase that. If you're the surviving spouse who's applying for DIC, and we just try to create a scenario here, hypertension, where your veteran spouse died of a stroke, or maybe he had a stroke 10 years ago and died 2 years ago, right? And maybe filed a claim and got denied service connection with that stroke. Maybe he was in a wheelchair or lost use of a couple of extremities after the stroke, things that strokes do. And VA denied the benefit and then denied DIC. As I'm reading this, Nemer would still apply to that particular person unless VA tries to interpret this only for the DIC portion of this benefit. In other words, under Nemer, that widow would get the 8 years of compensation for the stroke caused by the hypertension, plus the 2 years of DIC from the time that the veteran's been dead up to the present point. And the way I read this is that will still happen. So if you've got cases like that, if you're a widow out there and your spouse died of something related to hypertension and was denied benefits, this will likely have a big benefit for you, unless VA.
So what about if you are a Thailand veteran and you have something that's been pending for years? Are you still going to get that date because you've continuously appealed it, or is it the date of the act?
It's the date of the act for Thailand veterans from my reading of this.
Okay, so I mean, that's something that I'm concerned about. If someone's been appealing it and they've consistently appealing it for 5 years, they just don't get those 5 years. They get
and so everyone needs to be aware of that. That's a very good point. This is not going to end your appeals when not in a lot of cases, when going forward, when this passes, you might no longer have a fight with VA, but you're still going to be fighting for those retroactive benefits, and we're still going to be fighting those claims. So so it's not going to go away all of a sudden. So just keep that in mind.